Good evening, everyone. Thank you for coming. My name's Gordon Corera. I'm going to be moderating this evening over the next hour and a half at this event organised by Court Chambers. I'm a security correspondent for the BBC, where I cover national security, intelligence, cybersecurity, surveillance, those set of issues. We've had a couple of big political surprises this year in Trump and Brexit. I was in Washington last week trying to understand what Trump meant for national security. And it's fair to say that in a town where people pride themselves on their knowledge about what's going to happen next, no one had the slightest clue about what's going to happen. So it's great to be back in London where everyone knows what's going to happen with Brexit, because we all know Brexit means Brexit. And if you don't know what it means for this field of security, surveillance and home affairs, you certainly will when you've heard from our panel that we've got coming up. I'll briefly introduce them now, and then they'll each speak for about no more than 10 minutes, which will give time for questions from the floor. If the event is on the record, and it is also being filmed, if, like Donald Trump, you can't resist tweeting about everything that's on your mind, then the hashtag is Brexit Law, if you wish to take part in that. So briefly to introduce the panel, David Anderson from Court Chambers, the independent reviewer of terrorism legislation, will go first. Then after him we'll have Alison Duncan-Mercy here on my left, who's the Deputy Director for Strategy and Communications within the National Counter-Terrorism Policing Headquarters. Georges Bauer will go next, who is Deputy Secretary General of EFTA. Jemima Stratford, QC from Court Chambers, a leading litigator in EU competition and public law. Graham Smith from Bird & Bird, who is an expert on cyber and digital law. And then finally we'll hear from Yvette Cooper, who's here in her capacity as chair of the Home Affairs Select Committee. So, with that, let me hand over to David Anderson, who'll go first.
Well, good evening. You won't be getting many questions from me. You'll be getting some, or at least you won't be getting many answers from me. You'll be getting some headlines and then a couple of questions at the end, which I hope the experts who follow me will be in some sort of a position to answer. What I'm going to try and do is just give you some impressions of the field as a whole, security and surveillance, how Britain stands with Europe and how it might be after Brexit, and to try and identify what are perhaps the fault lines and some of the concerns. So I'm going to start off, if you like, at the complex end with the intelligence agencies, MI5, MI6, GCHQ. What is Brexit going to do to their operations? Well, my headline on that would be not much. They rely on their very good bilateral cooperation with trusted partners, most obviously, of course, within the Five Eyes, but also within Europe. But this is not a field where there are developed European institutions governing the way they operate. Indeed, there is a much debated provision of the Treaty on European Union, which you see set out there at the bottom. Like many of these provisions, nobody quite knows what it means, but we might be a little wiser in a few weeks. I've mentioned INTSEN there, and that looks as though it's a sort of EU intelligence hub, and it is. It's there to provide intelligence to the External Action Service, and the intelligence comes from the intelligence agencies and security services of the member states. But I think it would be fair to say it's not necessarily the most high-end stuff. Well, I was going to have a word about counter-terrorism, and before I did that, I have no idea if you can read this, probably not. But this is the latest Eurobarometer report on what people in Europe think are the two most important issues facing the EU at the moment. And this was taken, I think, in April and May of 2016. Terrorism is that sort of brown line that creeps along the bottom at about 5 or 6%. And then in 2014, just as the news of Daesh and their activities really gets going, it shoots up to the point that now 39% of citizens in Europe say that terrorism is one of the two most important issues facing the EU at the moment. It seems to be closing even on immigration, which has dropped from 58% last year to 48% this year. And although I won't show you the tables, that is regionally very imbalanced. In countries that have had terrorist atrocities, France, Germany now, Spain, Denmark, UK, you find high figures. In much of Eastern Europe, you find figures that are very low. And that's significant, as we'll come to later on. When it comes to counter-terrorism, and the message I really want to get across is that, contrary to the picture you often get from UK media, in this field at least, Europe is not something where other people do things to us. Europe is a field where we are undisputed leaders. And I've set out here a number of the things that we do and that we have effectively taken the lead on within the EU. So just yesterday, political agreement was reached on an EU directive on combating terrorism. That replaces two framework decisions of 2002, 2008. Tony Blair said, you might remember, after 7/7 in 2005, that the rules of the game had changed and some new criminal offences were introduced. You see those more or less faithfully reproduced in the EU directive. And more strikingly still, in the counter-terrorism strategy, again initiated during the UK presidency in 2005, but still operating, you see a pretty exact copy of the contest strategy that governs counter-terrorism in the UK. The only difference is, I think we call it prevent, pursue, protect, and what's the other one? Prepare. They don't call it prepare, they call it respond. So it's not quite so alliterative, but exactly the same principles apply. The Europol Internet Referral Unit, that's another straight copy from the UK. We have these people who we call spiders. They crawl over the web. They find stuff that really shouldn't be there because it's been posted by proscribed groups. And they notify the likes of YouTube, who, generally speaking, take them down. That's now been imitated at EU level under the aegis of Europol. It's operating very satisfactorily. And certainly when I've been to Brussels, I've been struck by the extent to which the British are said to be taking the lead on things like aviation security, how you look at risk. We looked at risk differently from the French. We persuaded the Commission to do it our way, and through that mechanism influenced the way that others do it. And very importantly, of course, managing the EU-US relationship, particularly where we've been looking at information sharing measures, passenger name records, financial details for terrorist financing, and so on. So we've been taking a leading role, and not purely in the counter-terrorism field. The European arrest warrant, we've obviously as a country sometimes had mixed feelings about, but we were one of the early adopters of it. Then the Data Retention Directive and the Passenger Name Records Directive, both very much driven through by Brits, not only in the British government, but also by British MEPs. At least one of them is here, I think. Sarah? Yes. She'll no doubt have something to say about that. The dates of these instruments are significant. When Europe moves on security, it tends to be in response to some atrocity. So the European arrest warrant was agreed just a few days after 9/11. Similarly, data retention after Madrid and London, PNR after the atrocities in Paris last November. And on other less glamorous or obvious things as well, rules across Europe that make it difficult to purchase ingredients of bombs, rules that mean that when a firearm is deactivated, it really is deactivated properly. These rules, of course, help us all, but the Brits are always very active in promoting them and steering them through. But it seems to me there are two fault lines in the British security relationship with Europe, and I've tried to summarise them here. And the first one won't be a surprise to anybody. It's our national wariness of compromising sovereignty. So you see that most obviously in our non-membership of the Schengen area, and consequences that flowed from that in terms of to what extent could we participate in Schengen-derived databases and so on, various cases in the European Court of Justice about that. You see it in our ambivalence, historic ambivalence on Europol. It's an institution that's been brilliantly led by a senior British police officer for the last few years. The government has very recently announced that it's going to be opting into it, at least in the short term, but we don't know what will happen after Brexit, and we may hear about that more from others. And then, of course, the hostility towards the European Public Prosecutor, and indeed to quite a number of measures which seek in various ways to provide minimum safeguards in terms of the application of the criminal law. So that's one difficulty, fault line. And the other, it seems to me, is the wariness of what I've called the rest of the EU of privacy intrusion. Of course, none of us like unnecessary intrusions into privacy, but I think it is fair to say that certainly the judiciaries of the UK and of Europe, if I may put it that way, do take a very different line in relation to those issues. And I've taken as the example the case of MARPA, which was a case about the retention of DNA samples. And the issue was, could you retain the samples of someone who'd been arrested but not charged or convicted? That case went up to the House of Lords. It was decided 5-0 in favour of the police and the government. Lord Brown even said, well, the only difficulty he had with the case was understanding how the contrary could possibly be argued. It went to Strasbourg, it went before the Grand Chamber, and the result was 17-0 in the other direction. They appeared to have an equivalent difficulty. And as Lord Sumption said in the case of CAT, there's a great tendency in Europe to characterise even minor or technical interferences with privacy as engaging Article 8, which had not, he said, historically been shared by the British courts. He went on to find that what he considered a minor interference with privacy did not engage Article 8, and we'll see what Strasbourg makes of that. But that's the Strasbourg case law. Even that, I think you can detect, for these reasons, quite a difference in tone. But even more so when you look at the case law of the ECJ, which I read in this area as developing stronger privacy protections than those we've become used to in the European Court of Human Rights. So I've referred there to the Digital Rights Ireland case. That's the one that actually struck down the Data Retention Directive of 2006 that I referred to earlier, and that is itself being interpreted in Tom Watson's challenge to DRIPA, the Data Retention and Regulatory and Investigatory Powers Act 2014. We're going to get judgment on that on the 21st of this month. And just to give you a flavour for what I mean, this is what the Grand Chamber of the Court of Justice had to say in Digital Rights Ireland about what you might call a plain vanilla kind of data retention. This is the power very familiar to all criminal lawyers to require telecoms companies to keep basic phone logs so that they probably produce them anyway for commercial purposes, or used to, but these would be the logs that would tell you who you were speaking to on the phone, for how long, what the number was that you were speaking to, and so on. Commonly used in all serious and organised crime prosecutions, for example, in drugs cases. Well, the Court of Justice in this case was looking at the EU directive and not at any national law. It's Tom Watson's case that will look at our national law. But they appeared to take objection to the fact that the collection of data was not restricted to a circle of particular persons likely to be involved in one way or another in serious crime. They certainly didn't like the fact that the retention of data was general, and they said indeed that this entailed a wide-ranging and particularly serious interference with fundamental rights. That, I think, just gives you a flavour for how differently the judiciaries look at these things. Well, pre-Brexit, I wrote a report in 2015, actually at the invitation of Yvette Cooper, who persuaded the Prime Minister to ask me to write it. I noted these differences, and I put out a conciliatory plea to the judiciaries in both countries, but perhaps particularly across the Channel, to recognise that these differences owe something, at least, to our different experiences of 20th century history, and that perhaps we should not be too intolerant of each other's attitudes. But I think perhaps the time for that is past. So I conclude by posting these post-Brexit questions, which I think arise as a consequence of the fault lines that I've identified. Bearing in mind the British influence in driving a number of these measures through in the past, it seems to me that one question we have to ask is, will EU measures be sufficiently useful in the future? In other words, is our absence going to show, and is it going to tell, in terms of what can actually be achieved and operated at EU level? And then the second issue, will UK participation in what is left be satisfactory? And that's perhaps the note on which to hand over to Alison Duncan-Mercy with her police experience, and after her, Georges Bauer, who, as Deputy Director of EFTA, knows exactly how Norway, Iceland and other countries have sought to involve themselves in these various mechanisms. Thank you very much.
David. Alison.
Thank you very much, and good evening. My name is, as David said, Alison Duncan-Mercy, and I am Deputy Director of Strategy and Comms at the National Counter-Terrorism Policing Headquarters. I timed myself earlier, so I'm going to try and stick to script. But I'm here to represent or to talk on behalf of counter-terrorism policing on not other elements of law enforcement who themselves have been feeding in to government in terms of their own sort of implications around Brexit. So there's a slight nuance with CT policing, which I will come on to. We have been working very closely with the Home Office and other elements of law enforcement in setting out what our priorities for CT policing are going forward in a future post-Brexit environment, so that can be considered as part of the government's negotiations. But I thought it might be helpful just to set out what our current operating model for CT policing is in the UK. By way of context, because we also have a very strong overseas footprint which is linked to this operating model. So we operate as part of a network, a collaboration of what we call CT hubs, which are based regionally across the UK, as depicted here. They are counter-terrorism units and counter-terrorism intelligence units, and we very much work as a collaboration which allows us to operate very much at the local level, regional level, but national level as well, where we have Assistant Commissioner Mark Rowley, who is the national lead for all counter-terrorism policing. But as part of that, we also have a very strong and increasing overseas footprint of counter-terrorism police officers, which I'm going to come onto. This actually allows us, this operating model really allows us to be part of local mainstream policing, but also to operate nationally and very jointly with MI5 on national security issues and also overseas. So our reach and what we call the golden thread of local to global policing is very strong. I've included this slide as a reminder of, this is a depiction of the threat or the numbers of foreign fighters that are travelling globally to Syria and Iraq, and including, as you see, just a reminder of the numbers that have travelled from Britain, but also Germany and France. And as many of you are aware, around 850 individuals of interest have travelled to Syria, around half of which have returned. And we've also seen many attacks recently sort of creeping more closer to the UK, where we remain at a threat level of severe, which means that an attack is highly likely. So the decision to leave the EU has come at a time where we have a sort of very shared and common threat. And we were already sort of deepening cooperation with our close European partners as we respond to this threat. Our ambition, even pre-Brexit, was to increase our connectivity and ability to create operational responses together with our European partners. And actually, and we get from our overseas network of police officers, and we know that we've not seen a reduction in cooperation from our partners since the referendum, and partly because of the very strong support we're able to offer some of our very close partners, such as the French and the Belgians, following the attacks there. So I would actually say, as a sort of measure of assurance or reassurance, that our relationships are probably stronger than ever because of this shared threat. And again, and David alluded to it earlier, but we are also, because counter-terrorism is part of national security, we also have this Article 4.2, which makes clear that intelligence and national security, which includes counter-terrorism, remains the responsibility of member states rather than the EU. And as a national security issue, much of our CT policing core operational work is conducted via bilateral relationships with overseas partners and also through this network of overseas officers, which I'll come on to a bit more. So like the intelligence agencies, we have built these over many years, and these relationships and mechanisms are strong. So I spoke just now about our UK-based operating model and how we are embedded with local and mainstream policing, but also how we operate with MI5. We also operate extensively overseas, and we've been doing that for over 30 years. where we have permanent police officers stationed either within diplomatic premises or as part of their local policing counterparts. Since 2015, we've also begun a process of doubling the numbers of overseas officers. And as you see from this slide, there are currently 8, we call them CTPLOs, permanently aligned to EU member states, including one in Europol, but these will be increasing to 11 in the near future. So the main aim, as depicted underneath, is to provide specialist expertise and advice on a range of CT-related matters. So they're more than just liaison officers. And we also deploy officers in addition whenever there is an attack or there is an investigation where there is a UK dimension or link. So, for example, we deployed officers quite heavily in response and in support of the Tunisian investigation following the attack in Sousse, where 38 people were killed, including 30 British nationals. This is the biggest loss of British life in a terrorist attack since 2007. We also provided, as I said earlier, support to the Belgian and French authorities, and we have strong cooperation with the German authorities as well. So our approach to Brexit has been, rather than trying to list all the various EU modalities that we feel are important from a CT policing context, is to really just set out what our our key operational priorities are going forward. And some of these are set out on this slide. I think to underpin this, our key objectives collectively is that we are all safer when as much information or intelligence about potential terrorists as is available can be known and acted upon, when their movements can be tracked and intercepted, when we know who is crossing our borders, when the guns or other weapons they might use in an attack are made less available, and when vulnerable people can be safeguarded, and when we recognise the dependency we all have on each other in our collective fight against terrorism, and we work jointly together to disrupt plots. And as I said, we are experiencing very good cooperation in all of those fields with our European partners. So our ultimate goal, and I thought it was really important to set this out, is we want to continue to help ensure Europe as a whole is a hostile place for terrorists and extremists. And from a policing perspective, we have been prioritising the following. So the amount of information and intelligence that is shared with European partners, we continue to strengthen and enhance. And this is not just linked to terrorism, because we do a lot of disruption through wider criminal activity that terrorists conduct, not just in the UK but also overseas. That we strengthen our understanding of the financing of terrorism so that we can seize and freeze assets. That we continue the work on cross-European work on firearms tracking and suppression of firearms. And that we have timely and high-quality advanced passenger data to ensure a better operational response. Also, that we have strong UK-Europe collaboration that maximises opportunities that borders provide. And, as was the case in the recent Paris and Brussels attacks, being able to work together with European police forces, both preventatively and in crisis, and where appropriate, their security intelligence agencies to support investigations and spot further plots. So I think that's a very quick canter, and I've probably stayed within the 10 minutes.
Great. Thank you very much, Alison. Thank you. So from the view from policing and cooperation with Europe, can I turn to Georges Bau, who is Deputy Secretary General of EFTA, and who can perhaps give us a view from an organisation which is attached to Europe, but not part of the EU.
Thank you very much. I feel a bit intimidated here in these premises and by this audience, as I'm neither an expert on terrorism, nor did I merit my position with the EFTA Secretariat. I'm just a political appointee. And so please bear with the bloody foreigner. Of course, Brexit raises a lot of questions, and most are related to the future relations of the UK with the EU. And many ideas have come up. A lot of papers on any issue is being produced, as you see every day in the newspapers. And some of these involve the EFTA states, be it by looking at EFTA as such, the EEA agreement, the Swiss-EU bilateral agreements, and lately Brexit was even, or it was even questions whether Brexit means exit from the EA agreement as well, and whether Britain could stay in there. We'll not dive into that today, but still, you see, there is a certain interest in what those closely associated countries of the rest of Europe or of the member states of the European Union do. And mainly also with regard to the security policy, because that is an issue that is only partly covered by the agreements, and therefore is a bit of a piecemeal approach. I would say the EFTA states are an example for associated outsiders in European security politics, or policies. It's a bit an odd bunch of countries. You have Iceland, Liechtenstein, Norway, and Switzerland, and they are linked in different ways to the EU. The only thing they currently have in common is quite some water, energy, and snow. I mean, they are the remainders of what once was EFTA, founded by the United Kingdom in the 1960s. So most of the then members chose to step over into the EU. And who knows, some dream of the UK at least coming back. Now, Iceland, Liechtenstein, and Norway participate in the EA agreement. Switzerland does not. They, however, or the Swiss, however, are linked to the EU by bilateral agreements, which is a bunch of agreements partly linking Switzerland into the internal market, but not really covered by institutional agreement. Therefore, it is quite difficult to handle. All four are members of the Schengen and Dublin agreements, and everything of that somehow relates to all four having different approaches to free movement of persons with regard to the internal market. It's a common element all of them share. So I would like also, in view of what has been discussed with regard to Brexit, to speak of a bespoke association with EU security policy and touch upon some of its elements. Most security-related aspects are not governed by either the EA agreement or the bilateral agreements. However, those memberships were the entry ticket for respective agreements like Schengen or Dublin. And probably all of the four EA-EFTA members, all of the EFTA states, all four, by accident are today members of Schengen and Dublin, because this was originally only reserved for EU member states. And because Norway was related to Sweden and Finland and Denmark in the Nordic Passport Union, they sometimes, when the Swedish and the Finns stepped over into the EU, they had to find a solution to maintain their open border. And in the end, this situation ended up by Norway and Iceland being admitted into Schengen as associated members. And finally, on that, the question came up, well, why don't other EFTA members not qualify as well for being members in Schengen, mainly those in the center of the continent, where you need to have some facilitations with regard to border crossing and so on. So Switzerland and Liechtenstein joined as well. So on the one hand, you have the association to the General Agreement on Border Control Without Passport Check, Schengen, and sub-agreements on information system, for instance, SIS. You have the same or the parallel association to Dublin with Frontex, the Asylum Support Agency, etc., etc. So most of the subsequent legislation has been taken over as well. Then with regard to, for instance, Europol and Eurojust, you have individual agreements by all of the four member states. These are rather cooperation agreements than a form of effective inclusion into these. Then you have the question of the European arrest warrant. There you don't have a direct applicability. However, individual agreements have been concluded. Norway has some kind of a surrender agreement. I'm not quite sure, but it could be that Iceland has the same. Or you have respective facilitations, like Switzerland, with simplified procedures, essentially based on the European extradition agreement. Then with regard to defense, it's only Norway, which is member of the EU Defense Agency. Switzerland having its neutrality. And then also more pro memoria, there is of course the EU data protection legislation covered by both the EEA agreement and Schengen, and thus applicable to all 4 of the EFTA countries. I think we will hear more about that a bit later on. And then on another side, you have the political dialogue, which sounds very innocuous, but it is de facto the association to CSFP declarations and measures. So not only do the EFTA states, mainly the 3 EEA-related EFTA states, support the politics and the policy of the EU with regard to foreign and security policy, but also support and take on some of the measures, for instance, with regard to Russia, or whether the Tamil Tigers in the past have been declared a terrorist organization. All of that has been supported or not, but at least the 3 countries have been taken into account and had a position to that. So I think I will stop here, as this was some kind of an overview, and thank you very much for bearing with me.
Thank you very much, George. Jemima Stratford.
I've been asked to talk about the EU's new General Data Protection Regulation and the implications of Brexit for data protection legislation in the UK. This is an interesting topic, not only because the regulation, the GDPR, as it's often called, constitutes a major reform of EU privacy law, but also because the GDPR provides an early example of how Brexit may impact on a specific area of law. First, the briefest of explanations of why the GDPR is important for those who aren't already familiar with its terms. At present, we have the Data Protection Act 1998, which implements the Data Protection Directive, Directive 95/46. From May 2018, that legislation will be replaced by the new GDPR. The new regulation was a long time coming serious discussions about its terms began over 4 years ago in 2012. The GDPR finally came into force on the 25th of May of this year, but doesn't apply until the 25th of May 2018. So from that date, when, of course, we now expect to be about halfway through the Brexit negotiations, the GDPR will be directly applicable law in the UK. And the government has now confirmed that the UK will be implementing the GDPR. So we're going to have a period of about a year, or at least a year, when the new regulation will apply, introducing very major changes into our data protection system, but we will almost certainly be in the process of extricating ourselves from the body which makes that law binding. Whatever the future relationship between the UK and the EU post-Brexit, personal data will still need to flow from here to the rest of Europe. And in practice, what that means is that our laws will need to be essentially equivalent to the EU regime. And that makes it particularly important to understand the GDPR. So what are its key features? Overall, the GDPR brings in new elements. The right of consumers to data portability is new, as is mandatory data breach reporting. It introduces higher standards of consent, and eye-catchingly, there are significantly larger fines for when companies get things wrong. So the maximum level of fines is up from £500,000 to over 20 million euros. The European Commission predicts that the new single law and simpler legislative framework will save businesses about 2.3 billion euros a year. That's a big claim, and time, of course, will tell how accurate it is in practice. So I turn now to the impact of Brexit. Once the UK leaves the EU, we will, as you appreciate, need to have a new data protection law in force. Elizabeth Denham, the recently appointed Information Commissioner, has already said she's having active discussions with ministers and other government officials about what that law should look like. Indeed, in a recent speech in Brussels, she said she was spending about a third of her time on Brexit. I want to make 3 points. First, as I've already mentioned, our future data protection legislation is widely expected to be extremely similar to the GDPR, at least at first. When the Secretary of State, Karen Bradley MP, used her appearance before the Culture, Media and Sports Select Committee a few weeks ago to confirm that the GDPR would be implemented in 2018, she also said that the government would, and I quote, look later at how best we might be able to help British business with data protection while maintaining high levels of protection for members of the public. Now, if this is more than mere political rhetoric, it may suggest that the government is considering whether post-Brexit it could remove some of the data protection obligations which are seen as more burdensome on business. For example, the Information Commissioner has suggested that the government might seek to abolish the obligation for smaller businesses to employ data protection officers. However, I predict that when the time comes, the government's room for manoeuvre will in practice be extremely limited. And this is because any departure from the standards set by the GDPR will put at risk the UK's prospects of obtaining a Commission adequacy decision so that data can continue to flow relatively easily to the EU. And Graham Smith is going to talk in more detail in a moment about the considerable problems that divergent privacy standards in the US have caused for international transfers. For now, I just want to stress that they show very clearly the cost that there would be to business, let alone to privacy rights, if our data protection standards were to depart materially from those which apply in the EU. Second, EU data protection legislation and case law is not going to stand still. The data protection package is one of the 21 key initiatives included in the Commission's work programme for 2017. Post-Brexit, the UK will no longer have a voice in the discussions and negotiations that lead to amendments and eventually, no doubt, replacement of the GDPR with something new. The UK will presumably cease to be a member of the new European Data Protection Board, which the regulation sets up. But to a large extent, we will have to continue to mirror the regulation's provisions. And what of case law? Again, this is an area where the data protection field may provide a concrete example of how post-Brexit UK will respond to the developments in EU law. With a piece of new legislation as significant and lengthy as the GDPR, it's inconceivable that there will not be references for preliminary ruling on its interpretation fairly soon after it starts to be applied. The UK will no longer be able to intervene and make submissions in those references so as to influence their outcome. And of course, the rulings of the Court of Justice will no longer bind our courts. There is therefore potential for increasing divergence between the approach taken across the EU on the one hand and the interpretation of certain key concepts offered by our courts. And here, the European Court of Human Rights in Strasbourg may offer a model, if not always an encouraging one. As is well known, our courts are not bound by decisions of the Strasbourg Court, but they must take them into account where relevant in accordance with Section 2.1 of the Human Rights Act 1998. It seems highly unlikely in the current political climate that post-Brexit our judges will be given a similar instruction in relation to judgments of the Luxembourg courts. Nevertheless, I predict that our courts will follow a similar approach, as they do with other comparative law materials from respected foreign jurisdictions. Where there's a European court ruling interpreting identical or materially identical legislation, I suggest a party will need to explain to the English court why the approach of the Luxembourg court is wrong and should not be followed. All very interesting for lawyers, but of course extremely uncertain and therefore difficult for everyone affected by the legislation. Third and finally, I was struck by a recent written ministerial statement on the reorganisation of the Information Commissioner's Office. The government's recommendation at the conclusion of the triennial review of the Information Commissioner's Office back in November 2015 had been for the organisation to be reconstituted as a multi-member commission. The review recognised that change would need primary legislation, but hoped legislative time could be found. But on the 8th of November of this year, a written ministerial statement rejected that proposal, citing not only the changes needed to comply with the GDPR, but also a need to prepare the organisation for, and I quote, changes to the data protection regulatory landscape after the UK exits the EU. So Brexit was squarely being given as one of the reasons for not embarking on a reform. The statement went on to stress that, and again I quote, strong and stable leadership is crucial during a period of rapid organisational change. I predict we'll see more examples like this over the months and years to come. The turmoil caused by Brexit and the sheer time that it will absorb in Parliament, preventing other legislative initiatives and reforms. I now hand over to Graham.
Okay, so I'm going to drill down from Jemima's talk into a very specific aspect of the possible need for an adequacy decision post-Brexit, and that is the surveillance powers which will be coming into force over the next year or so in the Investigatory Powers Act. So I'm going to assume that post-Brexit we are not past the EEA or EFTA or anything like that. We are a third country for data protection purposes as the United States is at present. And the rule then is that there can be no transfer of personal data from an EU member state to a third country, as you've heard, unless that third country provides an adequate level of protection, and the Commission can make an adequacy decision. The Commission did that in 2000 over the EU-US Safe Harbour Agreement. And if we jump forward to October 2015, we have the Schrems case brought by Max Schrems after the Snowden revelations of the large-scale surveillance that was being carried out by the NSA to strike down the Safe Harbour Agreement. And as is well known, Schrems was successful. He was successful on the basis that the Commission, a slightly technical basis, that the Commission hadn't made the findings that it needed to do about the adequacy of the US regime, but nonetheless the decision sets out some parameters by which to judge this sort of thing, and most importantly, it established that the surveillance powers in that third country are relevant to the adequacy decision that's going to be made, that's made by the Commission. In Schrems, the ECJ, as you've heard, said that adequacy requires essentially equivalent protection, not identical. It doesn't have to be achieved by the same means, but it has to be essentially equivalent. It recognised that national security is a legitimate objective, justifying interference with fundamental privacy and data protection rights, but interference has to be strictly necessary and proportionate to the protection of national security. And the focus of the Schrems decision was on what are known as bulk powers, what the NSA was doing, and what indeed Snowden also revealed that GCHQ was doing in programs such as Tempora. And if we look at what Schrems said about bulk powers, and this sort of followed on from the Digital Rights Ireland decision that you've heard about, you can detect a hostility to generalized activities. Legislation is not limited to what's strictly necessary, whether it authorizes on a generalized basis storage without any differentiation, limitation, or exception being made in the light of the objective, and then specifically in relation to content, drawing the distinction there between content of communications and the metadata surrounding, contextual metadata surrounding communications. Access on a generalized basis to the content would compromise the essence of the fundamental right to privacy, the significance of that being that if the essence of the right is contravened, then that is a per se violation. You don't go on to look at necessity and proportionality. Now, it has to be said that there is a lot of uncertainty and debate and dispute about what is meant in these decisions by concepts such as access. And when you look at bulk powers and the sort of processes from the collection, tapping into transatlantic cables and scooping out everything on a bearer, bringing it in, filtering, computerized analysis, storage, querying, human review, retrospective, data mining, computerized analysis, which of these are access? It doesn't really map terribly well onto the different stages in the activities that take place. But, and perhaps because of that, in the light of that sort of lack of clarity over quite what is meant by generalized activity in these areas, the Commission went back and has determined that a new agreement, the EU-US Privacy Shield, can be put in place instead of the safe harbour, and it is recognised in that decision that bulk powers can be a legitimate interference. So bulk powers go on and are accepted to a degree, albeit hedged around with a lot of safeguards and a lot of assurances from the US about some level of targeting or and controls that are applied in connection with these bulk powers. But nonetheless, as matters stand, we have a Commission adequacy determination in relation to the Privacy Shield, which accepts that bulk powers can go on. So we have a current adequacy baseline, which is the Data Protection Directive, read in the light of the EU Charter and interpreted by Digital Rights Ireland and Schrems. We have the essential equivalence test, which, when the GDPR comes into force, Article 45 spends half a page fleshing out the essential equivalence test. And we also have Strasbourg case law on surveillance sitting in the background, and we have the Privacy Shield decision. And in practice, if the Commission has to make another decision at some time in the future, assuming the Privacy Shield decision is still there and valid, then in practice it's going to be quite difficult, one would think, for the Commission to move significantly away from the types of findings that it's made in the Privacy Shield decision. However, the adequacy baseline may change. We have a number of cases pending. We have the Watson challenge to DRIPA, which David has told you about, with the judgment due on 21st December, which may have something to say of relevance. We also have an ECJ case on the EU-Canada passenger names records agreement, which is very much focused on use of passenger names data to engage in profiling and pattern analysis to detect potentially suspicious patterns of behaviour for further investigation. And we already have 2 challenges to the Privacy Shield decision brought by Digital Rights Ireland and a French NGO. And those, or at least the Digital Rights Ireland one, I assume the French one, focus fairly and squarely on bulk powers and say that essentially that bulk powers are inherently, so far as content is concerned at any rate, are inherently incompatible with data retention and privacy rights, and also suggest that the use of these powers to collect and analyze metadata is also incompatible. There's also a pending case in Strasbourg, 10 NGOs against the UK, and this is straight from Snowden, the Snowden revelations about the Tempora program and the PRISM receipt of PRISM data from the USA. So that will have to grapple squarely with the compatibility of bulk powers with under the existing legislation under RIPA with the convention, and we are promised or threatened with more challenges to the Investigatory Powers Act when that comes into force. So, just to wind up with some possible topics that might, or aspects of the Investigatory Powers Act that might come under scrutiny if there is to be an adequacy determination. Assuming that bulk powers are still found to be inherently compatible, I think in general one can say that the Act is long on safeguards, although some would say in some areas it's not long enough, but nonetheless there are a lot of safeguards in the Act, and most significantly the introduction of sort of independent prior approval by judicial commissioners of most warrants and notices. But arguably it is shorter on limits to powers, particularly in the bulk area. The bulk powers are very broadly framed, and the types of activities and techniques that can be performed under the umbrella of bulk powers range from at one end of the spectrum, something which is really very close to targeted interception, but done on a large scale, in the sense that you collect it off the cable, you run it through a buffer for a few seconds, you throw your selectors at it, which may be email addresses or whatever, and you throw it away. Throw away what doesn't get a hit, and you just take the hits forward, through to what's called sort of seeded analytics, where you start with some fragment of information from some nefarious activity, and you work your way out to see if you can find other associates or other suspicious activities connected to it, right through to the other end, completely unseeded pattern analysis and anomaly detection, where you are using data mining techniques to to use the data to find potential targets without any particular starting point of reasonable suspicion. So there's a very, very broad spectrum, and there are suggestions, I suspect there will be suggestions that perhaps those need to be treated differently rather than just all being lumped together under bulk powers generally. There's a blurring of the distinction between content and metadata in the ability now to extract various items of data from the content of, for instance, emails and treat them as metadata. And we have the entirely uncharted territory of bulk hacking, bulk equipment interference. And then separately, there's a whole area of mandatory communications retention, the Watson challenge, and the extended mandatory data retention for site-level web browsing histories. And lastly, it may be one area that may come under scrutiny is there have been a number of instances where legal interpretations have been adopted internally, powers have been exercised and asserted on the basis of those interpretations, which which came to light eventually, for instance, as a result of an investigatory powers tribunal challenge. There may be scrutiny of whether the Act does enough to ensure that in future those which really form part of the law, which ought to be generally and publicly accessible, whether the Act does enough to ensure that those are brought to public light in the future. So with those thoughts, I'll
Great. Thank you very much. Finally, Yvette Cooper with the view from Parliament.
Thank you very much. I'm just going to have just a few sort of thoughts really to wrap up from a more parliamentary perspective and the situation that we're in now. And this is a really challenging period, I think, for all of us. We've had a clear referendum result, and that means that Britain will trigger Article 50, whether it does through the royal prerogative or through the parliamentary route, depending on the outcome of the Supreme Court case. But we still know little about what the detail of Brexit will mean, or what the government intends to argue for as part of its negotiations. We hear today from the EU that they believe that the timetable, if Article 50 is triggered in the spring, will mean about 18 months of negotiations because of the time that will be needed in order to ratify the changes and the new treaty arrangements post-Brexit. And that is obviously a challenging timetable when we still know so little about what the plans are likely to be. Most of the debate in the end, and the political debate in Parliament, is likely to be around the relationship between immigration policy, single market access, and payments into the EU budget, and the debate around what people want, the debate around what is possible in the EU negotiations. Part of the reason that will also be challenging is because I suspect there actually isn't really even any agreement within the Cabinet around what it is they want to pursue and what Britain's approach should be. That makes it, however, even more challenging because actually, whichever the balance is, the detail is going to be hard to get right, and it's very difficult for everybody else to work on the detail if we don't know what the direction of travel will be. But to look at the policing and security cooperation, we as the Home Affairs Select Committee we took evidence today on what the key issues might be to get right around policing and security cooperation. We took evidence from the National Crime Agency and the National Police Chiefs Council, as well as from some of the academics who work in the field. And they were in no doubt that, to answer David's question at the beginning, are EU measures continuing to be useful, that certainly on policing and cross-border crime cooperation, there are a series of important EU measures that continue to be immensely useful, and that they want Britain to continue to be part of in some form or another. And that includes Europol membership or Europol arrangements with Europol, be that around the liaison group, around joint tasking and around Europol's databases. Secondly, some of the wider databases, the Schengen II database, the PNR, which some of those that they described, the SIS2, that they described as being a game changer in terms of dealing with crime and security. And then thirdly, arrangements for, if not continued a European arrest warrant, something similar or equivalent to the European arrest warrant. And those are the three areas that they said were the most important, and those that they wanted to see replicated in some form as part of the Brexit negotiations, and that if they weren't going to be replicated, they saw the risks to the UK in terms of policing crime and security would be higher as a result. At a time, particularly, look, when there is increased cybercrime, increased cross-border crime, trafficking, and when, as one of the witnesses put it, the amount of cross-border working will have to increase substantially over the next few years. It is not a time when we can afford to see a big shrinking in the level of policing and security cooperation that we are able to carry out. So what are the challenges and concerns in terms of achieving that? Well, the government has said that they want to sustain policing and security cooperation. I think this is an area, unlike some of the other areas around some of the single market access issues and budget issues and so on, where actually I think there is quite a lot of agreement and consensus across the government and probably more widely across the country as well. Everybody wants police to be able to work together across borders when pursuing criminals that cross borders or dealing with international terror threats and security threats that might put all of our lives at risk. So the question then becomes what is possible and practical given the 18-month timetable that's been set out. The first concern, so three main risks were set out, I think, emerged as a result of the evidence that we took. First was this key issue that we've heard the more legal aspects about this evening around the access to databases given the EU view of our data protection arrangements and what might be necessary in order to sustain our access to the Schengen II information system or the European criminal records database and so on, what might be made more complicated by the EU different approach to privacy and their view of our arrangements and the adequacy discussion that you've just heard. There was a certain point in which the debate and the discussions with evidence we were hearing this afternoon sort of became ever even more surreal when it became clear that, as we put it, so the complexity that we were already dealing with was likely to become even more complex as a result of the court case that had been started by the current Brexit Secretary against legislation that had been drawn up by the current Prime Minister, and that this might actually make it harder for both of them to get the outcome that they wanted in terms of policing and security cooperation. The second challenge then is the timing and how long that this might take in order to get this kind of detail worked through. And most of the witnesses that we heard from were of the view that it would not be possible to get a long-term sustainable arrangement around these areas agreed within 18 months, and that some form of transitional arrangement would be needed, whether it be around extradition or around policing cooperation or around information cooperation. And the third didn't so much emerge in the discussions that we had this afternoon, but has emerged, I think, in some of the other discussions that I've had and people that I've heard from. The third is, I think, a concern that the sort of political rows about some of the other issues means something like this could end up being squeezed and could end up not getting the political focus that it needs in order to drive it through and to make sure that sufficient appropriate agreements are reached. And also that it was at risk of becoming a bargaining tool from either side, from the UK or from the EU, in negotiations. It's clear, I think, that we have a strong interest, both in the UK and in the EU, in getting good cooperative arrangements in place. However, when I suggested to some of those who were involved in thinking about the negotiations whether policing and security cooperation could be treated as a separate chapter of the negotiations and could be just dealt with on its own self-contained way and maybe dealt with faster than some of the other areas, the view seemed to be that actually neither side would be keen to do that, because this might be something that could be played into some of the wider negotiations from either side. Now, there are considerable risks to that, because policing and security, which ought to be an area where we should have consensus both within the country and between the UK and the rest of the EU, surely should be something that we don't want to end up being squeezed in different directions just because it becomes part of a deal on some other aspect which is much more controversial for the arrangements. Final thought. This is going to be immensely complex, and I think there are challenges in terms of, for all of us, in terms of getting this right, that there are still, some on both sides, sort of some who voted to stay in the EU and are still almost in denial that this is going to happen, and who therefore don't want to engage in the detail because they're still hoping that somehow Parliament will overturn Article 50. It won't. Parliament will vote for Article 50 if it goes to Parliament later this year, in the beginning of next year. Secondly, there are some who don't want to engage in the detail because they say any engagement in the detail as being a betrayal, because somehow we should just be able to solve this instantly and instantly deliver Brexit. The shouting sometimes between those groups makes it harder for everybody else to then get on with actually working out how we are going to do this and to deal with the significant risks and challenges that we face. However, I had one glimmer of hope, which was that the protests outside the Supreme Court today seemed to have turned from the screaming and shouting to the humorous, with strange costumes being worn by those who were protesting as well. And I think if Britain can make the step of moving from shouting to humour, then actually that might make it possible for us to then have the space to engage in what are going to be some very difficult decisions indeed. Maybe that will make the politics easier, even if it doesn't make the legal challenges any easier to solve. Thank you.
Yvette, thank you very much. Thank you very much to all the panel. We do have time for some questions. I thought lots of interesting points came up. I thought Yvette's point about this area being squeezed is certainly possible in terms of the amount of time and resources that can be put into it and the limited amount in government to deal with Brexit. And I also, I've heard some officials talk about the sense in which they see security, including cyber security, is almost a card to be played during the negotiations, because I think there's a sense that that's an area where Britain has expertise and it's got something that Europe wants, and so it may be used in that way as a kind of bargaining chip. I thought another interesting theme was this idea that we've heard a lot about single market access, and that getting that will require playing by the rules. Well, certainly data flows and keeping data flows open will require playing by the rules, and rules, as with other areas where we may no longer have the ability to influence how those rules are set, we may not be in the room. And as David was saying at the start, we've in the past had quite a lot of influence in how some of those rules have been set, sometimes controversially, on things like data retention, and we may not necessarily have that in the future, and yet we may have to live by them to some extent. Questions from the floor? Do I have a few questions? One here.
My question is for David Anderson, QC. It's quite basic in many respects, but what piece of advice would you give to your successor, whoever that may be, keeping in mind the legal, political, and public pressures that he or she may face?
I would advise my successor to do the job in their own way. I hope there'll be an appointment, if not by the end of the year, then very early in the new year. I brought to the job what I can, but one could imagine all sorts of different skills being brought to the job that I didn't have. If I may put in a commercial for the Home Affairs Select Committee, they wrote a very wise letter today. It's actually signed by Yvette, and also signed by Harriet Harman, who chairs the Joint Committee on Human Rights. And they have asked that whoever replaces me or is selected to replace me should be required to attend. I don't think the word interrogation was used, but I think a little bit of friendly questioning, just to make sure that from their perspective, it's somebody who will be able to give them help. I think it's a very, very good thing to have a degree of parliamentary scrutiny, even if it's post-appointment scrutiny in these situations. And when the job was invented 40 years ago, it was absolutely at the request of Parliament, who said, well, we don't mind passing these anti-terror laws and even renewing them every 6 months, as it was then, subsequently every year, but we're only prepared to do it if you'll provide us with somebody who can look at the secrets and report to us on what's going on. That's still really the essence of what the job is about. I've always seen myself in part as a servant of Parliament, and I'm sure my successor will be the same.
David, following up on the Brexit theme of this, the ECJ has been such a dominant feature of some of the surveillance debates in recent months. I mean, do you think there's a feeling that with Brexit it will matter less, or do you think there's a sense it will matter just as much because of adequacy and all these other things, we'll just have to abide by the rulings?
Well, I gave evidence to the Bundestag in Germany on Thursday. I'm not their servant particularly, but they did invite me along. And I compared it to the Hotel California. I said there are respects in which we check out of the EU, but we're not going to leave. And I think as Jemima and Graham in particular have illustrated today, that's very much where we're going to be on some of this privacy and data protection stuff. With, of course, the crucial difference that, as Jemima pointed out, we won't have UK advocates there trying to influence the court. And if you talk to anybody at the Court of Justice, they will tell you that the UK advocates are the most influential before that tribunal. And we won't have MEPs, like Sarah and her colleagues, influencing the legislation, or indeed, of course, the British government in the Council. So this is a concern to me, that we will check out, we won't leave, and yet the two bodies will drift further apart, and there's not going to be very much we can do about it.
I had another question here in front.
I think that's my cue. Sarah Ludford, I'm the Lib Dem Europe spokesman in the Lords, but I was an MEP for 15 years and latterly worked on the General Data Protection Regulation. And I wonder whether it's fair to be rather pessimistic on this subject about the prospect of an adequacy decision. I was there and we were working on the regulation in 2013 when the Snowden revelations came out, and you know, the UK is very much seen as a Trojan horse, frankly. You know, the Investigatory Powers Act, in my opinion, in my party's opinion, has not helped, and I would, you know, be somewhat concerned on that aspect. It's not just privacy NGOs, but of course the European Parliament makes a lot of noise, justified, I think, most of the time. And on the Privacy Shield, for instance, the Article 29 Working Party, which is the club of national data protection regulators, is also concerned about the strength of the Privacy Shield. So I think all in all, one has to be somewhat concerned about the prospect of the UK being considered an adequate country for data protection in the future for these crucial, and of course not just the regulation but the data protection directive, which confusingly replaces the old framework decision on law enforcement. So, you know, are you more optimistic than I sound?
Alison, I wonder if you're optimistic. I mean, do you think it's going to make much difference to the policing world and the cooperation? Because a lot of it has been bilateral, but there's been shifts increasingly towards more multilateral EU-level cooperation.
Yeah, I mean, that's not my area of expertise, and I should also say, despite the fact that our approach has been to set out the operational requirements, a lot of the modalities that have been mentioned, EAW, Europol and all, we consider extremely important. And I think in terms of the investigatory powers and comms data and all of that, that's probably an area where policing has kind of stuck its neck out and actually set out the importance of some of this, simply because it sees it as such a critical tool in the policing effort. But I think our endeavour is to just maximise all avenues of cooperation. We're just enjoying operationally, or not enjoying, but experiencing operationally, you know, strong relationships at the moment.
Others on the panel, optimistic, pessimistic?
I think we have to pay attention to the timing here. A lot of these decisions that are going through the courts, whether it's Strasbourg or whether it's Luxembourg, decisions are going to come out long before before Brexit and before any adequacy decision is starting to be taken. So I suspect whichever way the landscape goes in terms of, for instance, the Investigatory Powers Act being compliant or not being compliant, I suspect the landscape will be much clearer by then. It may well be, if it's gone in a particular direction, that changes will have had to be made to the Act before we even do Brexit. So the fog may have cleared somewhat by the time an adequacy decision has to be taken.
And just to add, I'm sure you're right to say that there are some very real questions there. I suppose I'm being perhaps a little bit more of a pragmatist and thinking that realpolitik will kick in if post the Schrems decision they were nonetheless able to, the states were able to agree the new US-EU privacy shield. That shows perhaps what the necessity for business and individuals of having something in place, how strongly that drives governments and officials to reach some form of agreement. Whether we should have an adequacy decision may be a different question from whether there will be one.
I have another question here in the middle.
Thank you. Harold Chupak, as a practicing solicitor, could I perhaps ask Jemima and Graham and maybe David a question which arises from on listening to what you said? It seems to me that there is a tension potentially between the feeling which is exemplified in the new Investigatory Powers Act and the question of data protection and adequacy, which will be very relevant to businesses given the immense amount of data flows between the UK and the member states of the EU. And my question is, if we get to a position where perhaps there is a question mark over adequacy, are businesses going to have any way of trying to protect themselves in their contractual relationships, both with UK and foreign contracting parties, in relation to obligations which they've taken on, which involve free data flow and use of data, either perhaps by way of force majeure clauses or material adverse change clauses, and you could have the curious situation as to how will the English courts react, if those contracts are governed by English law, to a situation where the ECJ rules, perhaps as in Schrems, that something isn't adequate and shouldn't be allowed.
Which of you would like that one?
I'll leap in. I guess there's one point to be made about adequacy, which is that, and I should say I'm a IT and internet lawyer. I'm not a data protection lawyer, and if any of my data protection colleagues are sitting in the audience, they will probably string me up for even venturing into this territory. But there are countries. There are whitelisting decisions where countries have been generally held to be okay, and then there are decisions like the safe harbour decision and like contractual clauses and so on, where particular arrangements have been held to be okay. And of course, when it comes to something like the Privacy Shield, it wasn't just on the basis of the US law. There was a lot of particular assurances and representations and arrangements put in place which bolstered it all, which enabled the Commission to make its decision. So there are a variety of mechanisms which individually may or may not still be available, may still be available, even if one particular, I mean, who knows what type of adequacy decision we might be looking for anyway. There are, it's not totally black and white, I suspect. I don't know, Jemima, is that?
Yeah, absolutely, yeah. But these arrangements, I'm sure you know about, called binding corporate rules, maybe if you're thinking about the contractual position of businesses, and if we don't get to a position quickly where we have a general adequacy decision, that may be something that businesses will want to look at.
More questions? George, I want to ask you, do you feel, when it comes to this area of surveillance, privacy, security, do you feel that you are having to abide by rules over which you have no influence? You talked about Schengen, SIS, and some of these systems. Do you feel that?
To some extent, certainly. And maybe coming back to this last question also with regard to the GDPR and what's coming our way there. I mean, it is coming now through two channels, which is Schengen and the EEA agreement, and there is little way of influencing that. Now, Switzerland had an interesting position, which was a bit like that possibly Britain will find itself in later on, not being tied in any way contractually to the EU with regard to data protection, but still having to comply somehow and not having much say about how the material rules are being set. And here they were whitelisted quite quickly. And of course, they took into account the decisions by the ECJ on a national level and somehow simply went along. Now, because they are members of Schengen, of course, that will change because then they will be in a contractual relation with the EU, and therefore the GDPR will then change that situation a bit. But previously, it looked fairly similar, but quite clearly without having much to say on how to influence it.
Time for one or two more questions. Yes, we've got two questions here.
Thank you. I've got a question for Yvette Cooper, and I want to answer the question, assuming the Supreme Court decides it goes to a parliamentary vote. What I want to understand is why you don't think it's important as an MP to stand up for what you believe in and what you fought for, which was for Britain to remain in the EU. There seems to be some sort of parliamentary idea that we are not sovereign, the people are sovereign, and even if they were misinformed, we have to listen to them. Isn't that really what people are sick of? Is MPs thinking about their party careers rather than what they really believe in?
The problem is that we had a referendum. Now, if MPs had gone into the referendum and said, you know, we're going to have this referendum and we're going to campaign in this referendum and then we're going to ignore it, then you could have said, okay, you could expect MPs to then just decide to vote in the same way in Parliament as they voted in the referendum. But they didn't. Parliament voted to have the referendum, and many of us campaigned in it in good faith. We didn't campaign and say, we want everybody to vote Remain, but actually it doesn't matter anyway because we're going to ignore it. We said we want people to vote Remain because this referendum is important. And you have to, in a democracy, I think, respect decisions taken in good faith, because if you don't, actually you will get something much, much worse. If you say that you're not effectively going to respect the rule of law, if you say you're not going to respect the decisions that you've taken in good faith and that other people have taken in good faith, then I think you undermine democratic values that we have. So I did campaign very hard for us to stay in the EU, and I campaigned for us to remain, but I also think it would be wrong for Parliament to say it should just ignore the referendum result. I also think there is a big problem for people to simply say, well, actually, there was a result that we didn't like, but it must be because the people who voted in a different way to the way we did are somehow misled or are somehow not able to take the decision, or not educated enough to take the decision, or not informed enough to take the decision, or all of the things that I have heard said. I think the problem with that is it's going to just escalate the divides that we have in the country at a time when we have to be trying to heal them. And this is a difficult situation, and it is a very polarised situation that we are in at the moment. But I think if MPs were to take the response, the kind of course of action that you've said, I think you would actually make that polarisation much, much deeper. And you know, sometimes people kind of talk about what's happened with Brexit and Trump and so on as being the same. I don't think they are the same. I think that what people voted for in Brexit was they voted against a set of EU institutions. They did not vote for somebody who was saying that Muslims should not be allowed into the country, or for all of the things that, you know, I find quite horrifying in what Donald Trump was campaigning for. But I would just say, I think if you end up effectively thinking you can kind of rip up referendum results having campaigned for them in the first place, then it seems to me you are going down a Donald Trump track, and you are also provoking people across the country to go in that direction as well. So that's why I think actually the referendum result has to be respected. But I just think there's a huge amount that is still unresolved in this. This is not a kind of black and white situation we're in. The details of what happens next really, really matter. The wide range of options about what happens within Brexit is huge, and it will have huge, huge consequences. And if we stop debating what those range of options are and instead just go back to fighting the battles of the referendum, then actually the danger is we will drift into a really damaging, call it a hard Brexit if you like, whatever, we will end up drifting into some very, very damaging arrangements indeed.
Thank you. I have one last question here before we finish.
Nothing so far yet has been mentioned about Northern Ireland, and of course the UK faces quite a significant threat from dissident republicanism and Northern Irish related terrorism generally. Now Brexit will have quite profound implications potentially for the border between Northern Ireland and the Republic, and I was just wondering whether the panel had any views on what the sort of security implications of that might be.
Alison, do you want to say about the police?
Yeah, I mean, I should say from a sort of CT perspective, there is a distinction with Northern Ireland and PSNI, and they are very much at the table as part of law enforcement input into the negotiations. So they do have some very unique and distinct concerns and differences, as you've just set out, and all of those are being fed in. So, you know, they are much more reliant on things like EAWs, and the common travel area is a problem and an issue of concern. So all of those, as you would expect, have been highlighted and are hopefully going to be part of the government's considerations. And I know that in any case, borders and the CTA are sort of a high priority for government at the moment, and we are involved in some of those discussions.
Quick last word to David Anderson.
At one level, there could be security advantages in having a hard border. It's common, for example, for people to skip bail in the north and end up in the Republic. But I think the view taken by most people who've thought about this is that they would be outweighed by the disadvantages of a hard border. You'd have a very obvious and historically very resonant target, which then gives you the technical problem of how do you go about managing things without a hard border. Now, it might be all right if we're within the EEA and we're also within the customs union, but I think a lot of people would be saying we hadn't really left at all if we were in that position. If we were outside the customs union, well, we'd be rather like Norway, Sweden. They have a hard border there. I believe that there are only certain roads with customs checks. They're the ones that the lorries have to take. The others can go through so-called green lanes. But they certainly haven't found a way with all their ingenuity to avoid some sort of physical check. As far as people are concerned, it seems to me the most difficult category to deal with will be the nationals, not of the UK and Ireland. I mean, we've for a very long time had our own arrangements. I think within the EU there'll be quite a lot of goodwill towards us. They've invested quite heavily in the peace process. They'll want that to continue. Nor even with third nationals, so long as as Ireland stays outside Schengen, we have the common travel area arrangement. Seems to me the difficulty, and I don't know how this would be solved, would be with the nationals of other EU member states. If we're going to put restrictions on them that the Irish don't put on them and aren't allowed to put on them, and if we do not check them at a border in the middle of the island, then how do we do it? I mean, can we expect the Irish border force to do the job for us at Dublin Airport? Do we effectively leave Northern Ireland with some kind of different status and fortify the controls that we have on the Irish seaports and on the Great British airports? These are really difficult questions. The only reassurance I can give is that people are thinking about them, but I can't give any reassurance as to answers. I was just going to ask Gordon, will we have a quick final word each, or...
I will allow you a quick final word since you've asked for one.
Okay, well, I'm being very greedy, but let me just come back quickly on this question of adequacy and the Investigatory Powers Act. I entirely agree with what others have said. We don't know what any such decision would be. But I just make 3 points, perhaps slightly more optimistic than those you've heard from Sarah Ludford and others. One, the great thing about this act is transparency. The government and the agencies and the police have basically confessed to powers that one suspects a lot of other states operate, but which they do not enshrine in legislation. Equipment interference was mentioned. There's a very nice new shiny German law. You won't find much in that about equipment interference. Similar picture in places like Canada. And to my mind, that has taken a lot of the emotion out of the debate. This whole question of bulk surveillance, very emotional term. And I rather agree with Graham that we're in for an era now of people looking much more dispassionately and technically at how these various powers operate. Secondly, we may see that people begin to become more reconciled to these powers, if only for the simple reason that they're nearly all operated by the likes of Google and Amazon and so on, companies which very often take a strong public position against the use of bulk powers by the state. But which certainly don't scruple to examine the contents of our Gmails and our Google searches, etc., etc. And thirdly, on that, of course, a lot of people have looked at these bulk powers. I was one of them. Again, I'm afraid, set up by the Labour Party, which said it wasn't going to agree to this bill unless I spent 3 months looking at them over the summer. And one of the things I did was actually demonstrate that the sort of conclusions I was coming to, which was that these powers are A, very useful, and B, not as intrusive as people think, had already been reached by quite a variety of other people. In particular, the very low visibility but very high quality retired Lord Justices of Appeal, who for many years had been looking at these powers and reporting on them with increasing thoroughness. When I see a new judgment or a new Advocate General's opinion on the subject of bulk surveillance, the rule of thumb test that I apply is to look to see whether in the footnotes there are more references to George Orwell and Franz Kafka or to the Interception of Communications Commissioner's office. I've never found one yet that has referred to the Interception Commissioner, but there is quite a lot of good stuff out there, and I think there's a big educational job to be done. If George is getting a reply as well, may I put to him, this is being very naughty, 2 questions I have. He spoke about the European arrest warrant. He said that Norway and so on have surrender agreements, which perhaps are some sort of substitute for that. My question to him is whether he knows, do these surrender agreements allow for the surrender also of nationals by those countries who would not normally, on principle, extradite their own nationals? And then when he referred to Europol and the associate membership that he said some of these countries have, what in practice does that mean? I mean, do you get access to the same data, and do you get access to the same co-working operations, or is there a time lag, or do you not see as much, or do you not see it in the format that you find most useful?
George, do you want to reply to those and have a final word this one?
Very nasty indeed. Well, first thing, I'm not entirely sure, to be honest, how they deal with it, because I would assume if, for instance, Germany was in that position, they would clearly not do it. They would not hand over own citizens. So what kind of restrictions they have? If, for instance, Norway was asked to surrender a German resident in Norway and would be asked by a EU member state, I'm not entirely sure what would happen there. The second question is, they are all cooperation agreements which foresee, I've looked at some of them, to have relation officers in place in The Hague, and which obviously have access to most of the data. How deep this goes, I couldn't tell you either, but I think it goes quite far because this is somehow also related to Schengen. And they have, all 4 countries had to sign also these confidentiality and these agreements whereby you really commit to treat very confidentially all the information you get, and which can also be controlled by the other member states. So I think that goes fairly far.
George, thank you. Other members of the panel, anyone have any final prayer?
I'm not sure I was intending to be either optimistic or pessimistic about the prospects of an adequacy decision. I hoped I was pointing out areas of interest. But I think it's worth just developing slightly the fact that there are 2 different things here. One is the Commission doing an adequacy decision, which is at least partially going to be in the light of whatever decisions have been made by the courts, but also, of course, in the light of the fact that these similar practices are not unknown in other EU member states who will still be member states when the Commission comes to make an adequacy decision. So it is possibly a slightly political decision as well. But there's the second separate issue of whether if we get an adequacy decision and someone in the EU decides to challenge that, whether that would then pass muster in an ECJ challenge. And those 2 things may be significantly different.
Graham, thank you. Unless there's anyone else with a final word, I think we might not have all the answers, but I think we've definitely become more educated about the right questions to be asking on this field, thanks to the panel this evening. There is the chance for a drink afterwards, which is downstairs beneath us if you head down afterwards. But thank you to Brick Court for organising this event and for those who've been involved behind the scenes. And thank you again to the panel. Thank you.